Good afternoon, everybody. This is Steve Wilkes at the Wagner Law Group. Welcome and thank you for coming today. Hope you all are doing well. Today's webinar, we're going to take a little turn. The last webinar or two that I've done from the law firm has been focused a little bit more on the kind of the fiduciary practice, a little bit of securities, in terms of compliance procedures, social media, some things like that. As you know, we have a very broad based employee benefits practice here at Wagner, and myself, along with my colleagues, participate and work with clients in a lot of different areas. So I thought we'd maybe move a little bit today toward some plans, and particularly taking a look at the nonprofit sector, just to come up with some ideas. We get a lot of questions. A lot of people are contacting us about their nonprofit clients, and sometimes, in this general category, we include governmental plans as well. But I think for purposes of today, let's just think about the discussion in terms of nonprofit, because sometimes the governmental plans have slightly nuanced variations in the rules. So today, I thought we'd talk a little bit about Section 457F, which I know is familiar to many of you. By the same token, not always utilized. Could be a fresh idea to focus on. And I'm also going to talk a little bit about just bonus plans in general for nonprofits. I don't believe that was part of our actual emailing or advertising, if you will, out on this email. But I had a few communications from people that said, hey, what about a straight up traditional, bonus plan for our nonprofit clients? And that's kind of a world of its own as well, separate and distinct from 457F. So we're going to talk about that a little bit, and then maybe a couple of concluding remarks. And I think our next webinar, just so you know, I think I'll come back around probably in about 4 or 5 weeks. We'll give you a date, and I think we're going to go into a little more detail on some of the specifics and some of the technicalities of the bonus plans and bonus compensation arrangements for nonprofits, only because so many people asked about it. And I think it would be a good thing to refresh on. So when you think about where you're at, nonprofit, we see a lot of nonprofit clients. We have many clients, healthcare, hospitals, universities, social service agencies. There are a lot of entities out there, and there might be a core plan in place, 403B plans, which I know many of you are familiar with, and 457Bs, which are similar to the F we're going to talk about today, but they're a little bit different. That's kind of a core plan. It tends to cover a broader group of people, even though they're still limited. And we just get the question a lot from people. Well, what else can we do? Advisors will say, gee, I'd love to raise more assets to manage. I really want to work with my clients and add value. They have a core plan in place. What other things could I do for them? And similarly, the management team or the HR group, at the employer might say, hey, look, we'd like to do something in addition to our core plan, maybe something special for one or two of our key management people. And I want to mention that these 457F plans, hopefully motivate and reward people, but they also, because of the forfeiture and the way the vesting, kind of works to make the overall scheme work, it's kind of a good retention tool as well. And that is sometimes of value in, in any situation, but clearly in the nonprofit sector when you hate to lose good people from your management team. So that's kind of the context for how this topic came up today and why we're going to address it a little bit. So, generally these 457F plans, they're named after that section of the Internal Revenue Code. Again, as I mentioned before, they're different from 457B plans. Those B plans are referred to, as eligible plans, and a 457F is what we call ineligible plan. That's the way the code describes it. I think they can be pretty powerful. Unlike a 457B or a traditional, 401k plan or, a money purchase plan or something that's covered under the on the taxable side, there's no limit on the amount that you can defer under a 457F plan. So I think that's pretty powerful. right there. And, no caps, no annual limitations. I think the thing about the 457F plans that's, you might want to call it a disadvantage, that makes them a little bit different, is that the amounts that are deferred, they become taxable when they become vested rather than when they're actually paid. That's a little bit of a nuance to keep track of. So again, 457F plans, it's it's a type of deferred compensation plan that can be offered by a tax-exempt employer, by nonprofits. They're typically made available to one or more of the highly compensated employees. And by limiting your participation to this highly compensated group, and by maintaining unfunded status, which is a term of art under the code, these plans are exempt from most of the requirements of ERISA. So the 457F plans, a lot of times they look very similar to a more traditional non-qualified deferred compensation program. And again, the only difference is the way that they are is the way they're taxed. But they sometimes on the surface they look very similar to what you're seeing in the in the for-profit corporate sector. Again, the key being it's vesting versus time of payment in terms of tax. So these plans typically the way they're designed, typically a 457F plan, usually it might provide for employer contributions. It could be in a specified dollar amount. It might be a percentage of compensation. And another thing that's good to know here is that there's no cap on the amount of employer contributions that could be made under a 457F plan, the way there is under a 457B or 401K plan. Like I think this year 457B plans have an annual limit of $17,500. Over in the defined contribution space, generally there's an annual limit of, well, it used to be 51, it's raised to 52,000. You don't have those limits with 457F, and that's pretty good. You can coverage can be, you could do a 457F just for one person, maybe make it right as part of their employment agreement, or it could be offered to a select group of employees. And the contributions can vary. And I mean, effectively, you can discriminate. You can tailor the terms and conditions for each participant. The thing about the tax treatment is, generally speaking, the contributions and the earnings, in general, are not, generally speaking, they're not taxed until, the time when an executive withdraws them or is able to withdraw from the plan. But under a 457F plan, the contributions and earnings they're taxed in the year that the contributions are made to the plan, unless the contributions are subject to a substantial risk of forfeiture. That's a term of art that has a lot of, regulatory and judicial interpretation, but it's an important thing to remember. So if you have a risk of forfeiture, then the contributions and the earnings on the contributions are going to be taxed when that forfeiture provision lapse. In other words, it's kind of like it's when the employee becomes vested. And, earnings that accrue after that date when the contributions were made to when the plan becomes vested are not subject to taxation until distributed. So there's a little bit of a difference between the contribution itself and the earnings thereon in terms of the timing. So the way these plans are designed, there's a vesting to prevent immediate taxation. The 457F plans typically condition the right to payment on the performance of some future service, and that could be, forfeiture, in the event of a voluntary termination of employment before a certain date, or maybe, the attainment of an age, or the end of an employment term. And sometimes, you can be creative, and we can talk about involuntary termination and even bring it further to thinking about that in terms of termination for cause and not for cause. So there's a certain amount of flexibility that we can come up with in terms of designing how the termination provisions look. And I'm trying to think of a good example. For cause, is usually, like it could be a felony conviction or something like that. So the whole point is that you have a flip side here. On you have the employer contributions that you can talk about. There's also the ability to defer salaries. So you have this general rule that taxation occurs on vesting, and the IRS says, in order for a salary deferral to be effective as compared to employer contribution, there has to be a realistic possibility of forfeiture of that deferred amount if the employee terminates employment before a certain date. And there's been a lot of IRS guidance and interpretation on that. For those of you that like to get a little more technical, IRS Notice 2007-62 is one of the definitive pieces of published guidance on this. And what they're basically saying in there is that, absent tax considerations, a normal thinking, a rational participant, normally wouldn't agree to subject a right to amounts that may be earned and payable as compensation to a condition that subjects the right to the same payments to a real possibility of forfeiture. So in this situation, agreement to subject the amount to a substantial risk of forfeiture indicates that the recipient is confident that there's not a real risk of forfeiture and is only subjecting the amount to what they call a purported risk of forfeiture as a means of avoiding tax. So there are ways to work around this, these kind of restrictions and to structure compensation so that you can deal with employer contributions or look at salary deferrals, in a different light. And one of the things that I'm sure many of you heard about is the concept of rolling vesting. That's fairly common these days. It's not totally, I think we're pretty clear on it, though the IRS hasn't really issued a formal rule, but it involves extending the vesting date, and you can use a technique that's referred to as a rolling risk of forfeiture, like, a 5-year vesting period, extended for another 5 years, provided that the extension is elected before the end of that 5th year of service. So the IRS takes a hard look at these, but there's a way to, there's kind of a fine point or an art to, having a rolling vesting kind of schedule that we see as being fairly common. And generally speaking, of course, you all know about Section 409A or 409 Cap A. I mean, the whole world of deferred compensation really changed a number of years ago when 409A became effective. I think it was 2005. And this became a lot harder to engineer, tax-effective deferrals, and there's a strong public policy position behind that from the IRS. But and the penalty, 409A, might apply in certain situations, and the penalties for not complying can be pretty severe. So whenever we put restrictions and provisions on these plans, we need to think about, whether or not 409A will apply, or in the alternative to make sure it doesn't apply and that it's structured properly. And that's just, a very important aspect of the plan to keep track of. These things, as you probably know, 457F contributions and investments are typically placed in a separate trust. I mean, it can be in a book account, I imagine, at the employer, but we typically see them in a separate trust vehicle. They're usually called rabbi trust because of the private letter ruling that was initially issued on behalf of a congregation where a rabbi had a deferred compensation plan in place. And the thing about these rabbi trust agreements is that they have to provide that if the employer becomes bankrupt or insolvent, all the assets will revert back to the employer for the benefit of its creditors. But because of this, because you have this aspect, the plan is considered to be unfunded and part of the employer's general assets. So, that's one of the things that you want. That's one of the conditions, if you will, to getting out of most of the ERISA requirements. We found that executives typically prefer to have these assets placed in a rabbi trust because it might give them, an additional layer of protection. You would have an independent third-party trustee that's obligated to pay the funds in accordance with the terms of the 457 plan, and board of trustees have to honor them as well. So that's the thing about the trust. And also, typically, I would just point out, a lot of times participants direct the assets in a rabbi trust, but it's also an opportunity, and very often we see an advisor, working, with the investment or providing advice on those. So it's an opportunity on the advisor side as well. I think that there is one ERISA reporting aspect to this, even though you're not subject to most of the requirements of ERISA. These plans are called, considered top hat plans. Top hat plans. You have to do a filing with the DOL. Someone asked me, where the name Top Hat came from. I don't know if you all know this, but Top Hat actually came because it was kind of a caricature of the executives, with their high hats, their silk high hats on Wall Street. The exclusive few that are eligible to be in these plans, and they just started calling them Top Hat plans because that was kind of a little bit of a picture of the people that it covered. But the point is, if you do it properly, you're going to get out of having to file a Form 5500. It's a pretty simple filing. I have to say, we see a lot of 457F plans that appear to be in pretty good shape. We might amend them a little bit or do a little bit of fine-tuning for 409A compliance or what have you. But there's been a failure to file the one-time filing with the DOL, and that's something that we would help a client correct. And if you have plans in place, you want to make sure that that's been taken care of. So that's kind of just a quick overview on the 457F plans. I think if you think about it, it provides a little additional deferral for some people. And I think that because of the way the vesting works, it becomes a very effective retention tool, which I think a lot of employers find helpful, because if you don't stick around long enough, you're going to forfeit. So I'm just going to shift over now again, just a little bit more on the nonprofit side, but talk a little more generally about just bonus plans in general. Again, because I received some requests up front to include this, and as I said earlier, we're going to come back around to this in about 4 or 5 weeks and go into it in depth, because it's a world of its own. But the thing I would say about these plans is that these nonprofit organizations kind of have their own special rules of financial management and how they govern themselves. I think one of the key constructs of these 501c organizations is that revenues have to be used to achieve specific goals, rather than just creating a surplus that gets distributed as a profit or as dividends. And so even though a nonprofit organization can have compensation packages and bonus plans that they kind of look like what you see in the for-profit sector, they kind of derive from a different set of governance rules, in terms of best practices and corporate purpose under state law, but also from the IRS point of view. And the IRS looks very, very closely at how these things are structured. I just want to point out that there are various 501c organizations that we could talk about, but I think for purposes of the bonus plan, we're just going to assume that they're all the same, and they get into some of that. They spell that out pretty clearly in the Internal Revenue Manual. So the IRS has come up with like a 12-factor test of compensation as to when it's reasonable in the 501c world. And they say that a bonus is permissible even if it comes a little bit on earnings, or it's based on earnings, if you will, or net earnings, if the entire comp package of the individual is reasonable and it furthers the exempt purpose of the organization. So this is something, of course, that's always decided in light of all the circumstances and the facts. There's a couple of key court cases out there. I think the Scientology Church has a leading case on this that kind of sets some of the standards for it. So I'm going to get to I'll go over the factors in a moment, and I would say that just generally speaking, that when the IRS is looking at whether compensation is reasonable, they tend to include all the forms of compensation. It's the base comp, it's the incentive comp, and it's any other benefits that are provided. So this 12-factor test is pretty interesting. What are they? It's based, by the way, on a general information letter that came out from the IRS. I'll talk about it in a minute quickly. But basically speaking, I think what they're saying is, and this is food for thought for you that are working with 501c organizations, or if you are part of the management at a 501c. Number one, the plan has to be established by an independent board of directors or some sort of compensation committee. You need to have a good process in place. It needs to make sense in terms of the function, the level of the job, and kind of the geographic location. They like to see that it's the result of some sort of arm length bargaining. They like to see some sort of a ceiling, a reasonable ceiling, or reasonable limits that are in place, a maximum, if you will. They like to see that the payment of this plan doesn't kind of reduce or impact the ability of the organization to operate, provide services, or other benefits. That it does consider the actual performance of the employee. It's within budget, that paying this kind of bonus scheme doesn't increase fees in any way. That it doesn't actually transform this 501c entity into what ends up being a for-profit business venture, between the entity itself and its, and the key manager or the executive. It's not a device or a scheme to move profits or assets out of the organization, to insiders or, controlled persons, disqualified persons. There's a valid business purpose served. In other words, every 501c organization has a valid business purpose, and the payment of the bonus or compensation scheme, it should be in furtherance of that. Doesn't provide unwarranted benefits, and the services are actually performed. So you can see that's kind of a different mindset, a different set of filters than what you would get on the for-profit side, because it very much is honed in on the charitable purpose or the specific, nonprofit purpose of the entity. But I do want to point out that there are plenty of bonus plans and schemes and compensation programs in place, and they just need to be reasonable in light of these criteria. So, and you get this. This comes out of the IRS regulations. It says that to be a 501c3, it says an organization has to. An organization won't be considered a 501c3, I guess the way they word it, if more than an insubstantial part of its activities are not in furtherance of an exempt purpose. That's one thing, that's important. And the other is that there's, an organization that's not operated exclusively for one or more exempt purposes, if its net earnings inure in whole or in part to the benefit of private individuals. So stated in plain English, there's a prohibition against the private, movement or inurement of net earnings to people. And then there's some terms of art. I mean, an insider, who's a related party, who's a disqualified person. Those are, those relate to, officers, managers, substantial donors, people that have influence. Inurement has its own meaning. It means a benefit to someone, for personal gain, perhaps. So, again, the whole purpose of this regulation and to limit the plans and compensation structures to make sure that the organization is serving its, its public purpose, its charitable purpose, rather than, some sort of private purpose. I think that gives you a quick, maybe a quick look at some things to think about in addition to the 457F. So just by way of recap, if you're working in the nonprofit sector and you're working with your, you're advising a management team, whether you're, some sort of financial consultant or you're part of the organization itself, it's a very common question that comes up is, what else can we do for our people? We have a core plan in place, and we've seen a lot of 457F plans over the years, and they're still of interest to people. Not everyone has fully thought through about how they might impact their organization yet. So I think that that's an area where you can provide some good tax planning, some good incentives, some good deferrals, and you can be very targeted and very selective with them. But they have some special wrinkles under the law, and they have to be handled in the proper way. And obviously we could help you do that. I think if you're an advisor, it's an opportunity to potentially manage more assets. If you're on the corporate side itself, it just could be furthering a good corporate objective of not only your compensation policy, but retaining executives. The bonus plan section is a little broader, just really a reminder that it's okay to have bonuses and special payments, if you will, to your management team and to your employees, but it kind of comes from a different place. It has to be looked at in terms of, the charitable purpose of the entity, or the social purpose, the public purpose, and you have to make sure that there's a lot of published IRS guidance that comes in the form of information letters and rulings and court cases and whatever. So you have to navigate a little bit, but they're definitely available, and that's something that we're going to talk about in a lot more detail in our next webinar, because we've had some strong interest in it. We've done a lot for some people, and we're continuing to get questions. So I'll focus on the next webinar a little more detail on really what private benefit and private inurement really means. We'll talk about the downside of excise taxes if you do it wrong. The IRS realized a while ago that, gee, if someone makes a mistake on their bonus plan, we don't necessarily want to lift their 501c status. That seems pretty harsh. So there is a regime of excise taxes, they're referred to as intermediate sanctions under 4958. We can talk about that. Some general guidelines on what's reasonable, some things to consider on reporting this stuff out in Form 990, maybe how to build in some deferral mechanisms into these agreements, and just generally some best practices in that area. So on that note, I hope I didn't go through that too quickly. I think we covered some food for thought there, and if you have any questions or we can be helpful in any way, please let me know or contact anyone in our firm. And in a day or so, these PowerPoints and a recording will be available on our website. So please avail yourselves of that if you would like. And let me know if you have any further questions. Thank you very much for joining us today, and we look forward to our next webinar, which will be around the end of April. Thank you very much.